Okay, so hello everyone. I know most of you are new. This is the second class only, right? So briefly in 2-3 minutes or 1 minute actually, let me tell what we are trying to do here. Okay, so that is the one thing that you should keep in mind. See, daily what I do that I take one topic from law optional and I explain that topic in quite detail, that what are the subtopic that need to be studied in that particular topic. Then I talk about what are the major case laws or what are the concept that is related to that particular topic, right? The purpose is to enable you to study by yourself, okay? So that even if you take a book, you should know that you can pinpoint that, okay, in this topic these are the things that need to be studied, right? So that is the purpose of this particular class, right? And at the end of the class I give you one a question to write, and that question I evaluate. Obviously a lot of people send me the PDF, right? But some of the PDF actually I evaluate and I will show you in this lecture itself, right? So that you can improve upon them, okay? So that is how the whole system functions, okay? So those who are new will understand that. Now someone is asking what to cover. I will come to everything, okay? So not to worry at all. No, any doubts and anything I will request you to ask here itself, right? Because individually replying to each and every email is a very tedious task. Hope you understand, right? 100 email replying and conversation is very tough, right? And the other good thing about asking here is that you can ask here and maybe some other student have that particular query, right? So that can also get fulfilled, okay? You can raise your hand, I will unmute you and we can have a chat there, okay? Here itself, okay? Now let us start today. See, if we look at today's total class, right? Let me share the screen. Yes. See, let us start now. What actually I was talking here, I will be talking in the course of this whole lecture, is basically there are two topics. If you remember, there are two topics in the law optional topic, right? The topic 2 and topic 3. So topic 2 actually suggests fundamental right, public interest litigation, legal aid, legal service authority, and topic 2 is fundamental right, relationship between them, DPSP and fundamental duties, right? So this fundamental right and relationship between them, it means ki article 14 relationship with other article 19 relationship with other article, and the relationship of fundamental right and DPSP, right? So there is a very huge complex relationship in the terms of fundamental right and DPSP, right? What are those relationships? So the first important relationship, if you remember, is basically the relationship related to some of the noble things that the constitutional maker wanted to write in the fundamental right but could not write it. Okay, so that is one thing, right? You should keep in mind here. And then we have relationship between fundamental right and fundamental duties. Okay, so I will have to switch the tab and I have to see that if someone is waiting, I have to actually I will have to actually admit them all, right? So that is sometime it will differ. Okay, so please bear that in mind. Sometimes that might happen. Okay, so I will keep checking it and I will have to admit it. Okay, now when I am in the different tab, I cannot see what you are typing. Okay, so please refrain from typing, or you can chat among yourself, right? I am not able to see that. Okay, you can chat among yourself and then we can come here. Okay. Okay, so let me first complete my lecture, then I will see whatever the problem is. Okay, now if we look at the subtopic related to these two topics, so you can see here that the first topic actually relevant is the fundamental rights evolution, relationship between DPSP and fundamental duties, right? So that is the first subtopic. It means it have clubbed these two, right? It have clubbed these two. Okay, then fundamental right specifically and its initial provisions, detailed provision with respect to the fundamental right only. Okay, article wise provisions. Okay, so that is the second part, right? So the first aspect is mostly philosophical. Okay, the relationship between the fundamental rights, relationship between DPSP and fundamental right. Second is totally mostly it is the question is mostly direct in nature, right? Article 19, article 14, article 28. Okay, direct. Then we have a specific topic, PIL. Now this PIL has to be studied in multiple dimensions, right? We will talk about it. And that again, legal aid and legal service authority, right? So what I have done, that I have disintegrated this two topic into 4 subtopic, right? So today I will be dealing with only first subtopic, then I will be dealing with the little bit about fundamental right, or tomorrow I will talk about in detail the individual provision of fundamental right, then I will be talking about PIL and legal aid later on. Okay, so these two topics I will cover in 3 classes. Okay, so that thing you should keep in mind. Okay, so that is a huge number of things that is needed to be understood here. Okay, now let us start. First is the fundamental right evolution itself. Now I have to go back again to the Zoom. If someone is waiting, I will have to. Yes, I don't think anyone is waiting, so that is okay. Good. Now I have muted you all, right? And I am not looking at it. Okay, so please don't type anything. I will just see once we will go there. Okay. Now let us start with the major purpose of fundamental right. Okay, philosophical aspect. Now if you look at the philosophical aspect of the fundamental right, one thing is very clear, right? How does the fundamental right functions, right? What is the purpose of fundamental right? See, in any constitutional democracy, if that constitutional democracy has to function, then in a constitutional democracy, the person who is in power, who is basically in majority, that person will always have an added advantage. How? Because they can pressure the government to protect their interest. But what about minority? Minority cannot pressure the government politically, or they cannot threaten the government that okay, next election I will see you, or something like that. That cannot happen in the case of minority, right? So only in the case of majority they can protect their interest, right? So the primary purpose of fundamental right sometime is to protect the minority from the rule of majority, right? So that is the first philosophical purpose of fundamental right, protecting minority, right? All over the world you will see that the fundamental rights have been designed, and in that design you will see that definitely there is always an aspect related to certain rights given specifically to minority, okay, because they cannot protect their interest, right? Second purpose of the fundamental right is that in the case of majority as well, if you don't want, if you are not satisfied with the government, right, so what is the best thing that you can do? If you think about it, what is the best thing that you can do? You can practically ask the government that okay, these are the things I needed you to do, but if you will not do these are the interests that needed to be protected, but if you will not protect the interest, in next election I will unseat you, I will not give you vote. But that next election is 5 years away. Then how come your immediate interest can be protected? Okay, so here the fundamental right comes at rescue, right? You can immediately go to the court and get the relief. Okay, so basically it is protecting normal citizenry from the might of state. Okay, so fundamental right sometimes acts as a protective umbrella from the citizens against the state, right? So that is the second philosophical purpose of fundamental right, protecting umbrella to citizens. Okay, protecting umbrella to citizens. Okay, so that is the second purpose of fundamental right, right? So you should remember that, right? Now how the fundamental right evolved. Okay, now if you look about the fundamental right evolution, the evolution basically happened in three ways. Okay, first they said that okay, fundamental right is basically a code in itself. Okay, it means it is a straight closed jacket, and it have no relationship with anything else. And the best case, the best example of case is basically your ADM Jabalpur. Okay, if you will look here, I have AK Gopalan, not ADM Jabalpur, AK Gopalan, right? Here the court practically said, Justice Mukherjee, that there cannot be any such thing as absolute or uncontrolled liberty whole free from restraint that would lead to anarchy and disorder. Okay, meaning each fundamental right has to be seen its own natural aspect. It has not to be seen with other natural aspect. Okay, so that is a very interesting thing that actually happened, right? That the court actually said, right? Now if you look at in the later years, the court started to digress from this particular view that fundamental right is a straight jacket, totally no relation with any other fundamental right, only one fundamental right, right? Now some notification is coming, I think more person is waiting. Let me admit that also, them also. Now this Mac have given me today, धोखा दिया. It is not functioning. That is something very bad actually. Okay, Principal AK Gopalan. Yes, I will explain you, Prerna Sarthi, not to worry. But let me go back here itself. Okay, and the question I will take later on. Right. Let me first finish what I have to talk today. Okay, let me first finish. Okay, so in AK Gopalan, if you will see the evolution of fundamental right? So the initial year the court said that no, it is a straight jacket. Okay, it means no other thing can come into it, right? Each fundamental right is code in itself. Okay, it have no relationship with anything else. And the best example is AK Gopalan. Later on the court said that no, that is not the case. Sometimes the fundamental right can have relationship between them, right? Between them, that is the main point here. Between them, okay, means ki 14, 15, 16. Okay, 14 with another provision, equality with right to freedom of religion, okay, equality with minority rights, okay. So there have been a relationship between two type of relationship. First, 14, 15, 16, between a particular state type of categories of fundamental right, that article 14 to 18, there is a relationship between them, right. Later on they said that no, there is not only relationship between 14 to 18, but the relationship is between different categories as well. It means right to equality category have a relationship with right to freedom of speech, right to freedom anything, okay. 19 to 22, okay. It means the code evolved naturally, okay. Now I have here given you 3 examples actually, right, that the court have evolved. The first example is of article 14, 15 and 16, the relationship between article 14, 15 and 16. And second, I have given you relationship between article 14, 19 and 21, Trinity, you must be aware of it. And the third is article 29 and 30. Now that is a very interesting article, okay, article 29 and 30. Now if you look at these articles in detail, so I have given certain case laws, right, but I will suggest to you when you read your MPGen or whatever book you have, right, you do not go to every aspect of it, just only read these that I am telling you, right, because that is the only thing from where the most probably the question will come, right. So need not to digress into much detail and talk about everything, okay. So that is the one thing you should keep in mind. Now let us start with suppose 14, 15 and 16. Now in 14, 15 and 16, 2 cases actually evolved, okay. Sorry, one case is the most important case is basically state of Kerala versus N.M. Thomas, 1976 case. Now to understand this case, one thing actually I will have to explain is basically constitution itself. Let me open the constitution for you, and if we will see the constitution, a very interesting things come into picture. Let me open it, give me a minute. Article 14, yes, okay. So what is the relationship? So in initial year court said that see, article 14 is providing you with equality, and article 15, article 16 or article 17 is the exception of article 14, right. Understand it clearly. Okay. Article 14 provides for equality, 15, 16, 17 and is not 17 but the mostly 15 and 16 is an exception of 14, meaning everyone will be treated equally, but if certain conditions given in article 15 is satisfied, then exception can be granted to you, right. Now this have a very wide implication. It means that if suppose we are talking about reservation, and reservation I am saying is exception to article 14, then it means that if there is a law permitting reservation, then that must satisfy the requirement of article 14. Okay? So if the law has to satisfy the requirement of article 14 providing for reservation, then only the law will be valid. Okay, now that will create a problem. Suppose आपने एक law बनाया, उसमें आपने law में कहा कि reservation देंगे, right? अब आप कह रहे हैं this law satisfies 15, but 15 is exception to 14, so it must also satisfy 14. Okay, it must not also violate 14. Now that created a problem. So in the case of this N.V. Thomas case, court laid down a very different guideline. It said that no, article 15 and 16 is nothing but it is not an exception, but it is basically giving the effect to article 14 itself. Okay, now that led to a situation where the reservation related law need not to satisfy the requirement of 14. Okay, so that is something very unique, right? Let me read here itself. Article 16 clause 4 indicated one of the method of the achieving equality embodied in 16 clause 1. 16 clause 4 do not exhaust the equality of opportunity which can be made available to backward classes. The guarantee equality before law, that is 14, something more than the formal equality. Okay, so it means it is not the exception. Article 16 is trying to implement what article 14 is saying. So if a law passes the muster of article 16, it will be not hit by article 14 at all. ठीक है, तो कितना आसान हो गया गवर्नमेंट के लिए रिजर्वेशन देना. समझ में आ रही बात, ये क्लियर है, राइट? सो दैट इज द व्यू दैट एक्चुअली द कोर्ट ट्रांसग्रेस्ड, राइट? दे फाउंड अ न्यू रिलेशनशिप बिटवीन 14, 15 एंड 16. अंडरस्टूड? क्लियर है? गुड. Now I will have to go and look any question if anyone have. I don't think anyone have any questions. Yes. Let me see if someone is waiting also. Okay, no one is waiting as well. Okay. Now let me come to second type of article, right? Second type of relationship is basically article 14, article 19 and article 21. Now if you look at the article 14, 19 and 21, it is a trinity. right? So A.K. Gopalan again, it said though personal liberty means liberty concerning the body of the individual, right? Obviously it have been overruled multiple times, most recently in the case of this right to privacy, Puttaswamy judgment, right? That privacy do not only include bodily privacy but also the informational privacy. It means that any information regarding your body around, that also will get covered under article, right to life and personal liberty. However, I will discuss individually article 14, 19, 21 later on. So this is only the first part, that is the relationship between the fundamental rights. Okay, so that is the part that is a lot of questions is asked, because specifically the topic is given. Okay, then R.C. Cooper came and they said for the first time article 21 have a relationship with article 19.1. Okay, how the relationship is, let me explain you. I will explain you. But before that, let us go to Menka Gandhi, and they said that no, it is the requirement that both of three of them forms a trinity. Now, what is exactly the relationship between them? Okay, so let me, I have tried to write it down here. The concept of reasonableness must be projected to in the procedure contemplated in article 21. Now, what is this concept of reasonableness? This is the concept of new concept of equality given in article 14. Okay, so let me briefly tell you here. See, normally what is happening here, article 14 is saying that okay, equality should be there, and equality should be substantive equality, procedural equality as well. Okay, article 19 provides that reasonable restriction can be imposed on freedom of 7 type of freedom, and 21 says that due procedure of law should be followed. Okay, so what is the relation? The relation is that if you are saying the procedure, it means that procedure must satisfy the requirement of equality as well. It means that procedure must not be unreasonable. The relationship between 14 and 21. Okay, now when we are saying the reasonableness, right, like in the case of freedom of speech on the ground of public order, a ban can be imposed. Okay, because public order is under the ground, is under one of the reasonable restriction that can be imposed, right? Now, when we apply that particular reasonable restriction in the name of public order, then that reasonable restriction must not violate your life, that is article 21, and must not violate the equality requirement of 14. मतलब ये कि यू कैनॉट हैव ए अनरीजनेबल क्लासिफिकेशन, किसी को बोलने देना है, किसी पे रोक लगा रहा है कि भाई तुम्हारे बोलने से पब्लिक ऑर्डर वायलेट हो रहा है, तुम्हारे बोलने से पब्लिक ऑर्डर वायलेट नहीं हो रहा है. दैट यू कैन नॉट डू. ओके, सो इट मीन्स कि द प्रोसीजरल इक्वलिटी प्रोवाइडेड अंडर आर्टिकल 14 must be satisfied by any action under article 19 and article 21. Okay, so that is the relationship, that is the court talks about, that is the golden thread that runs through the entire fabric of fundamental right. Okay, multiple times this question have been repeated, right? So this is the basic concept. Now I will suggest you go to the MP Jain or whatever book you have, Jain Pandey or whatever, you please read that. And someone was emailing me yesterday, sir, should I read H.M. Sarvai? It is a stupid thing to read H.M. Sarvai. समझ में आ रही है? मैं भी H.M. Sarvai तभी पढ़ता हूँ जब PIL फाइल करना हो या कुछ डिटेल में जानना हो, because H.M. Sarvai explains article 14 in terms of this reasoning. Okay, कि if every law is unreasonable, does it mean that all the unreasonable law is invalid? ओके, तो वो सिलोलिज्म का इस्तेमाल करता है आर्टिकल 14 को समझाने के लिए, राइट. इट इज मच डीपर, वो आपके लिए है ही नहीं, इरेलेवेंट है, राइट. तो जैसा मैंने पहले ही बताया था आपको क्लास में कि डोंट हैव टू डू PhD. ओके, तो जो सीधा सीधा मैं बता रहा हूँ, जो टॉपिक मैं कह रहा हूँ, बस रीड दैट इटसेल्फ. ओके, डोंट गो इन डेल्व इनटू मच डिटेल, नॉट गोइंग टू सॉल्व योर पर्पस. ओके, now the third relationship that I will be discussing is article 29 and article 30. Okay, now if you will look at article 29 and 30, what does it say? Let me actually open the constitution itself, there I can explain you in a much better way. Let me open the constitution. Yes, see, this is the article 29 and 30. Yes, if you will see clause 1, what it is saying, that any section of citizens residing in any territory of India having distinct language, script or culture have right to conserve the same. Clear? Now the court said that okay, it says section of citizen, it means कि it need not to be minority. That is the point. Okay, it means कि section of citizen means कि they can conserve their culture without acquiring the status of minority. When we talk about article 30, it specifically talks about right of minority, right? Now why this question of article 29 arose? Because article 29 says protection of interest of minority, but here they do not define minority. Understood? So court said that minority as well as non-minority can actually protect their own culture and language. Okay, but the right granted under 30 to open an educational institution, that is specific to minority. Okay, and that is again an exception to Article 15 and 16, if you remember. Article 29 and 30, certain clauses are exception to 16 and 15. Okay, there the court said very interestingly that in the case of clause 2 of Article 29, which says that no citizen shall be denied admission into any educational institution. Okay, now this educational institution will consist of minority educational institution as well. ठीक है, मीनिंग कि इफ़ यू आर रिसीविंग फंड फ्रॉम स्टेट, अगर आप पैसे ले रहे हैं तो आर्टिकल 29 में आपने माइनॉरिटी इंस्टीट्यूशन बना लिया. ठीक है, तो इसका मतलब ये नहीं है कि आप भेदभाव करेंगे रिलीजन के आधार पर. यू कैन नॉट डू इट. ओके, क्योंकि आप स्टेट फंड ले रहे हैं. ओके, सो इवन इफ आर्टिकल 29 क्लॉज 2 ये कहता है कि यू हैव अ राइट टू कंजर्व योर ओन एजुकेशनल इंस्टीट्यूशन बाय ओपनिंग एजुकेशनल इंस्टीट्यूशन, स्टिल आर्टिकल 29 क्लॉज 2 के हिसाब से आप उसमें भेदभाव नहीं कर सकते. इट मीन्स कि ये सेकुलर आर्टिकल है. ठीक है, इट मीन्स कि इट इज़ नॉट ओनली प्रोटेक्टिंग द इंटरेस्ट ऑफ माइनॉरिटी एजुकेशनल इंस्टीट्यूशन, बट इट इज़ द प्रोटेक्टिंग द इंटरेस्ट ऑफ एवरी एजुकेशनल इंस्टीट्यूशन इंक्लूडिंग माइनॉरिटी, प्रोटेक्टिंग द इंटरेस्ट ऑफ चिल्ड्रेन हु वांट्स टू गेट एडमिशन इनटू दैट. समझ में आ रही बात, ये क्लियर है. तो 29 और 30 का ये रिलेशनशिप है. मैंने यहाँ पे लिखा भी अच्छे से, एक बार रीड कीजिएगा तो समझ में आ जाएगा. देखिए, 29 क्लॉज 1 confers right on any section of citizen, thus including majority also. मैंने बताया था वही कि 29(1) में भले ही यहाँ माइनॉरिटी लिखा हुआ है, ठीक है, लेकिन सेक्शन ऑफ सिटीजन इंपॉर्टेंट है, मीन्स एनी सिटीजन. समझ में आ रही बात, ये क्लियर है. दूसरा 29(1) इज कंसर्न विथ 3 सब्जेक्ट ओनली, 30 डील्स विथ माइनॉरिटी. ओके, यहाँ पे एक बड़ी इंटरेस्टिंग सी बात इन्होंने यहाँ पे लिखी है एक्चुअली में, इसी जजमेंट में है. बड़ा फेमस जजमेंट है ये, सेंट जेवियर्स कॉलेज एजुकेशन. ठीक है ना. इसमें एक बड़ी इंटरेस्टिंग सी चीज़ ये लिखी हुई है कि द कंजर्वेशन ऑफ लैंग्वेज, स्क्रिप्ट और कल्चर अंडर 29(1) मे बी बाय मीन्स होली अनकनेक्टेड विद द एजुकेशनल इंस्टीट्यूशंस. ओके, तो एक आर्गूमेंट एक्चुअली में फ्रेम किया गया था काउंसिल से कि आर्टिकल 29 में जो स्क्रिप्ट और लैंग्वेज और कल्चर की बात की जा रही है, 39 बेसिकली प्रोवाइड्स वन ऑफ द मेथड ऑफ कंजर्विंग द सेम, एंड द मेथड इज टू ओपन एजुकेशनल इंस्टीट्यूशन. कि बाई ओपनिंग एजुकेशनल इंस्टीट्यूशन यू कैन कंजर्व अ पर्टिकुलर आर्टिकल, राइट. तो अगर ये रिलेशनशिप आप कहते हैं ट्रू है, इसका मतलब है कि आर्टिकल 29 विल ओनली अप्लाई टू माइनॉरिटी इंस्टीट्यूशंस. ठीक है, इट मीन्स द स्कोप ऑफ आर्टिकल 29 हैज़ टू बी गवर्न्ड विद द आर्टिकल 30 स्कोप, राइट. द कोर्ट सेड नो, इट इज़ नॉट द केस. क्या कह रहा है कोर्ट? द कोर्ट इज सेइंग दैट 29(1) may be wholly unconnected with the educational institution, right. तो एजुकेशनल इंस्टीट्यूशन खोल के ही माइनॉरिटी के राइट्स प्रोटेक्ट नहीं हो सकते हैं. इट इज wholly unconnected, right. इट इज अ सेकुलर वन फॉर एवरीवन. समझ में आ रही बात, की क्लियर है. सो दैट इज समथिंग वेरी इंटरेस्टिंग द कोर्ट सेड. नाउ दिस इज अगेन फर्दर हैव बीन इंटरप्ले हैव बीन फर्दर एक्सपाउंडेड हियर इटसेल्फ. ओके, इसमें ये बात ज़्यादा ध्यान रखेंगे. बिटवीन लेटर एंड between the tradition of past and convenience of present, between the society's need of stability and need for change, right. So the article 29 and 30 interpretation have been taken by the court in such a way that the society need to change, the society need to evolve. Okay, so that is a very interesting relationship between 29 and 30. Okay, I think I have covered this 3. Now let us come to the individual articles provisions. Now let me again see if someone is waiting or something like that. Okay, yes, someone is waiting, 2-3 people. Okay, now those who have arrived late, not to worry, I will provide you with this, this whole lecture itself I will provide you with. Okay, now let us come to the individual provision of fundamental rights. So the first part actually we have finished, right. I have told you that the 2 topic here I have divided into 4 subtopic. So this actually I have finished the first part. Okay, the second part I will go into the individual articles. Okay, now if you look at the individual articles, I have only covered today 13 and 14, so 12 and 13. From 14 onwards I will cover tomorrow along with the major case law. Now in the case of 12 you must be knowing it, very famous, the state definition of a state. Now one philosophical aspect that you should keep in mind regarding the definition of a state is that Article 12 governs the reach of fundamental right. What do you mean by it? It simply means that when we expand the definition of Article 12, it means that we are adding multiple institutions into Article 12, right. Now once a particular institution is added in Article 12, it means that institution has to necessarily follow the fundamental right. Okay, so if the court want India to be a welfare state, so what the court will do, that court will add every other institution which is providing social benefit into the definition of Article 12, right? And that will lead to a very interesting situation. Okay, so that is the primary purpose, right? So that is the primary purpose, right? Hope you all understand it, right? So that is the primary purpose. Clear? Quite simple. Now, if we look at the cases that how this evolution have taken place, right? The whole evolution have taken place, right? Then you can see here is the three major cases actually. First is the electricity board versus Sukhdev Singh. A person actually died, electricity ka tar toot gaya tha and someone actually fell into the one of the electricity wire and he died. Then the question arose that whether the electricity board will be covered under state or not. The court said yes, it is performing a statutory function. Okay, it is authority under the constitution or have been at least delegated by the constitution. Okay, so then that is okay, very restrictive type of view. Then RD Sethi International, the court laid down these 5 criteria, just a Sayyar judgment actually it is. If it is financial resources mainly coming from the state, the government, deep and pervasive control, right? Deep and pervasive is important part here. Okay, now what is pervasive? It means it is controlling each and every layer of that organization. Functionaries of the government of public importance. Now that is something very important actually. Function of the, right? That is something sometimes also referred as that a state have an institution have acquired the characteristics of a state. Acquired the characteristics of the state meaning if you are performing a function which the state is supposed to perform, then you has to be held accountable with respect to state. It means you have acquired the characteristics of the state, right? Now this particular point was overturned by this G telefilm case, BCCI case, right, where the court has held that no, always acquiring the characteristics of a state do not mean that you have to perform necessarily public function. So that cannot be the exclusive criteria. What happened in the case of BCCI? Basically, some of the people went to the court saying that the BCCI is representing India all over world, and even if it is not a state, it is functioning it is performing a function which is practically fixed for the state. So it have acquired the characteristics of a state according to RD Sethi International. The court threw that out, that no, that is not the only criteria. So right? So it means, philosophically speaking, you can think or you can say that the state definition, the widening of state definition is basically one of the criteria, one of the process by which the court widens the very scope of the fundamental right itself. Okay, so that is something you should keep in mind. Okay, then Article 13. Now this Article 13, obviously the whole Kesavananda Bharati and the main focus would be on the word law. What do you mean by law? So when I will discuss Kesavananda Bharati, that is your constitutional amendment, I will talk about them in quite detail. Okay, so I am trying to restrict my lecture into 30 or maximum 40-45 minutes. Okay, so I think in 30 minutes I have explained this. Okay, now what I will do, that I will check some of the copies. No, first let me give you the today's question. Okay, write it down, everyone, please write down the today's question. Write down, I am giving the same question itself. Write down fundamental right, DPSP, the active principle of state policy, is nothing more than fundamental right which is also, ऐसा मत लिखिए, इसको मैं फिर से मैं डिक्टेट करता हूँ. Nothing more than unenforceable fundamental right, ऐसे लिखिए. Nothing more than unenforceable fundamental right. Comment. Right, so this is a philosophical type of question. It means I want you to contrast. I want to take you from article from DPSP. I want you to take from the article of the fundamental right and compare. Okay, if you're talking about equality, this DPSP article is trying to enforce equality. ठीक है, जैसे अगर आर्टिकल 38, 39 आप देखेंगे, they are trying to enforce social equality, right? So you will pick out the article from the fundamental right section and you will compare it with them, and then finally you will conclude that yes, DPSP is nothing more than a fundamental right, but it have been made unenforceable due to limited economic capacity of the state. और एक एग्जाम्पल उसमें कंक्लूड में ये भी आप लिख सकते हैं कि as the state capacity improves, the best example that you can give there is basically right to education, right? That has been already made fundamental right. ओके, सो आपको कंपेयर करना है, राइट। तो ये इस टॉपिक का पार्ट एक्चुअली में अगर आप देखें तो टॉपिक यहाँ था जो फर्स्ट का, रिलेशनशिप बिटवीन देम। ओके, रिलेशनशिप बिटवीन देम, राइट। तो स्पेसिफिक टॉपिक लिखा है लॉ ऑप्शनल में, रिलेशनशिप बिटवीन देम। ओके, सो वो फिलोसफिकल पार्ट है, क्लियर है। चलिए अब मैं क्या करता हूँ कि कल के कुछ क्वेश्चंस चेक कर देता हूँ। मेरे पास बहुत सारे लोगों के क्वेश्चंस आए थे, आंसर आए थे, सॉरी। तो इसमें कुछ आंसर्स मैंने निकाले हैं, करीब 17-18 मेरे पास आंसर्स आए थे, राइट। तो उसमें से मैंने 3-4 ही निकाले हैं, और मैं सबको प्रयास करूँगा कि मैं रिप्लाई कर दूँ, लेकिन 3-4 मुझे अच्छे लगे और कुछ इसमें ख़राब भी हैं, ताकि मैं उसमें आपको गलतियाँ बता सकूँ, ये कर सकते हैं। जैसे ये कविता है बालिका ही, सी हैव रिटन आई थिंक अ वेरी गुड थिंग। What she talks about the meaning of constitutionalism here, not uncontrolled and arbitrary, limited power may lead to authority. Very nicely she have written, good. Now the whole positive and negative aspect, इसी से काम चल सकता था, no need to write this. Not just the limit power, okay. Positive aspect, good. Paragraph change करने के बाद criticized by several scholars. There is no constitution which can interpret or enforce itself. It must be. देखिए ये पार्ट जो है इसको थोड़ा सा इम्प्रूव यहाँ करने की ज़रूरत है। द मीनिंग इज़ नॉट क्लियर, इम्प्रूव हेयर। इंडिया स्ट्रेस, नाउ देखिए क्वेश्चन को इन्होंने सीधे सीधे लिख दिया। नो व्हेन आई टॉक्ड अबाउट कि आपको वो लिखना है हेडिंग एंड सब हेडिंग, तो इसका मतलब ये नहीं कि क्वेश्चन ही लिखना है डायरेक्ट। ओके, हेडिंग सब हेडिंग नया बनाइए, ठीक है ना, या न्यू वर्ड्स के इट हैज़ टू बी। ओके, यहाँ पे कॉन्स्टिट्यूशनल गवर्नेंस, वी कॉन्स्टिट्यूशनलिज्म लिख सकते थे, तो दैट वुड हैव बीन गुड हेडिंग, बट स्टिल प्राइमरी एडिफाइस ऑफ इंडियन डेमोक्रेसी। ओके, गोपालन तो बड़ा ही बेकार सा जजमेंट है, राइट, ऑलमोस्ट ओवर रूल्ड। ब्लैक डे भी कहते हैं कभी कभी इस जजमेंट के डेट को। ओके, कॉन्स्टिट्यूशन देखिए आपने वही चीज़ लिख दिया जो मैंने लिखा है, इसको 1 by 1 भी लिख सकते थे आप, ABC, राइट। तो इससे स्ट्रक्चरिंग और बेहतर होती। ओके, जो एग्जामिनर है उसको चेक करने में आसान होता है, क्योंकि इन्होंने बताया है कि व्हाट आर द प्रिंसिपल इन द ऑफ द कॉन्स्टिट्यूशनलिज्म। ओके, बट स्टिल अब इन्होंने कॉन्स्टिट्यूशनल टेंशंस की बात की और यूनिक इन परस्पेक्टिव, गुड। इसको यहाँ पे लिखा कीजिए, ठीक है ना, यहाँ पे थोड़ा सा प्रेजेंटेशन भी अच्छा होना चाहिए। ओके, emphasized, that is also okay. Besides having some criticism provided, ठीक है, दिस इज ऑल्सो गुड, राइट। तो अगर मैंने इसको 20 मार्क का दिया था तो मैं आपको इसमें 11 मार्क्स अवार्ड करूँगा। ओके, नाउ वन आंसर आई विल शो यू दिस आंसर। This answer I don't know who the student is, I don't remember actually. Oh, he have written a very good thing, but what is the lacking here? The part that is lacking here is the presentation and structuring. ठीक है, कहीं भी इन्होंने अच्छे से स्ट्रक्चरिंग नहीं की है। देखिए कहीं भी इसने, हालांकि इन्होंने पॉजिटिव एस्पेक्ट यहाँ पे लिखा है थोड़ा सा, ठीक है ना, लेकिन ये देखिए स्ट्रक्चरिंग में ऐसे आप पॉइंट वाइज नहीं लिखेंगे, समझ में आ रही है, पैराग्राफ वाइज लिखेंगे। उसके बाद पैराग्राफ के अंदर 1-2 पॉइंट चलेगा, पूरे के पूरे आंसर को पॉइंट वाइज लिखना सही नहीं है। समझ में आ रही बात, ये क्लियर है। तो इसका मतलब यहाँ पे थोड़ा सा स्ट्रक्चरिंग इसका इंप्रूव किया जा सकता है। कंटेंट बहुत अच्छा है इस बालक का, जिसने भी लिखा बालक या बालिका, वेरी गुड कंटेंट, राइट, बट ओनली थिंग दैट इज नीडेड इज बेसिकली स्ट्रक्चरिंग इंप्रूवमेंट लिटिल, ठीक है। तो चीज़ें काफ़ी अच्छी हो जाती है यहाँ पे, ठीक है। रूल ऑफ लॉ, इंडिपेंडेंस ऑफ जुडिशरी, गुड। आई मीन वही उन्होंने लिखा है जो हमने यहाँ पे लिखा हुआ था। नेगेटिव एस्पेक्ट, लिमिटेशन, ठीक है, ओके, नो नीड वाई टू राइट दिस, ठीक है। ये आप ट्रांसग्रेस कर रहे हैं क्वेश्चन से, ये ऊपर लिखिए, यहाँ क्या मतलब है, इंट्रो में ये जाना चाहिए था। अब देखिए इसका भी उन्होंने ऐसे पॉइंट बनाया है, समझ में आ रहा है कि पैराग्राफ है या हेडिंग है, कितनी खराब स्ट्रक्चरिंग है। गवर्नमेंट पावर, आर्बिट्री, यस। देखिए तीसरा पेज हो गया, मतलब ये 300 वर्ड पार कर चुके हैं। एक पेज में करीब 100 वर्ड मान के चलते हैं, 70-80 वर्ड, ठीक है। तो प्लीज़ डोंट एक्सीड द लिमिट। इम्पोर्टेंट रामेश्वर प्रसाद, यूनियन ऑफ इंडिया। ठीक है, बट कंटेंट तो ठीक है, लेकिन स्ट्रक्चरिंग और प्रेजेंटेशन में मामला ख़राब है, ठीक है ना। तो मतलब मैं आप इसमें अगर देखा जाए तो 20 में आपको सिर्फ यहाँ पे 8 मार्क्स अवार्ड करूँगा, ठीक है। और भी बहुत सारे लोगों का आंसर है, राइट, लेकिन ऑब्वियसली सबको मैं इंडिविजुअली रिप्लाई कर दूंगा। जैसे आई थिंक दिस सी हैव रिटन नाइसली, यस दिस, अच्छा ये तो वन ऑफ माय लॉ ऑप्शनल स्टूडेंट, यस यस राम्या, गुड, सी हैव रिटन इट नाइसली एक्चुअली। व्हाट इज कॉन्स्टिट्यूशनलिज्म, कॉन्सेप्ट ऑफ पॉजिटिव एंड नेगेटिव एस्पेक्ट, सी वेरी नाइसली, फर्स्ट लाइन, प्रॉपर हेडिंग, मीनिंग, यस, प्रोहिबिट द स्टेट फ्रॉम डूइंग, वेरी गुड। यहाँ पे नेगेटिव, चलिए पैराग्राफ चेंज क्या करेंगे, तो ये चेंज हो गया था, ठीक है, ओके। परफॉर्मिंग द टास्क डिसेबल, बस ठीक है, लेकिन ये पलक पार्ट थोड़ा सा अच्छा लीगल वर्ड इस्तेमाल होना चाहिए यहाँ पे, ठीक है ना, थोड़ा सा इम्प्रूव कीजिए इसको। पंजाब सर्वाइव चेंज वर्टिकल, यस, इट मीन्स कि कह रहे हैं कि कॉन्स्टिट्यूशनल गवर्नेंस इंडिया में काम कर रहा है बिकॉज ऑफ द हिस्टोरिकल रीजन्स, ठीक है ना, राइट। तो यहाँ पे हिस्ट्री सपोर्ट्स या ऐसा कुछ करके एक हेडिंग भी डाला जा सकता था। और सुप्रीम कोर्ट आरसी गोपाल, दिस कॉन्स्टिट्यूशनल कल्चर ऊपर में बात हो गई है, आप यहाँ पे सिर्फ कॉन्स्टिट्यूशनल गवर्नेंस की बात करनी है, ठीक है राम, प्लीज इम्प्रूव दैट। कॉन्स्टिट्यूशनल गवर्नेंस में बेसिक स्ट्रक्चर कैन बी एडेड, लेकिन ये पेपर 2 के लिए ज़्यादा सही रहेगा, ठीक है ना। कॉन्स्टिट्यूशनल गवर्नेंस को बेसिक स्ट्रक्चर से ऐड करना थोड़ा सा स्ट्रेच ऑफ इमेजिनेशन, बट इनकरेक्ट तो नहीं होगा ऑब्वियसली। इसमें रीसेंट डालिए ना, वो मैंने आपको बताया लोक प्रहरी वाला केस डालिए, जो भी बिल्कुल रीसेंट है कॉन्स्टिट्यूशनल गवर्नेंस के बारे में, राइट, दैट हाउ द सुप्रीम कोर्ट एक्चुअली रिसेंटली वेकेटेड द बंगलो, राइट। सिमिलरली आप एनसीटी दिल्ली वाला केस डाल सकते हैं, देयर द कोर्ट सेड दैट द कॉन्स्टिट्यूशनल गवर्नेंस रिक्वायर्ड द कॉन्स्टिट्यूशनल फंक्शनरीज टू नॉट बिट्रे द कॉन्स्टिट्यूशनल ट्रस्ट प्लेस्ड इन देम, राइट। सो दो सॉर्ट ऑफ लाइन हैज टू बी रिटन, ओके। तो नहीं लिखा आपने यहाँ, ये यहाँ पे क्रिटिसाइज़ कर रहे हैं आप कॉन्स्टिट्यूशनल गवर्नेंस को, राइट, बाय डिफ़ॉल्ट तो ये टॉप में ही जाना चाहिए था, यहाँ पे इसका कोई मतलब नहीं है। डॉक्यूमेंट ओनली, यस दैट इज़ ओके, राइट। देखिए इन्होंने कंटेंट भी इनका ठीक है, थोड़ा सा पुअर है, लेकिन कोई नहीं, इट इज़ गुड एक्चुअली, मोर देन एवरेज एक्चुअली। उसके बाद में स्ट्रक्चरिंग भी इन्होंने प्रॉपर की है, प्रेजेंटेशन देखिए कितना अच्छा है, राइटिंग इज ऑल्सो गुड, राइट, एवरीथिंग इज क्लियरली विजिबल। तो ट्राई टू राइट समथिंग लाइक दिस, ओके, राइट। सो इसमें मैं आराम से इनको जो है 13 मार्क्स दूंगा, okay, good. Now I will come to here and I will ask you all to ask any question that you might have. Sorry, yes, you please raise your hand. You please raise your hand. I don't know where I can see everyone here. मुझे अपनी ही शक्ल नहीं दिख रही है कि मैं कहाँ पे हूँ। अच्छा, मैं यहाँ पे हूँ, okay. Yes, I can see now. Yes, now please raise your hand and I will one by one unmute you, okay? Yes, I am unmuting Mr. Realme X. Yes, please go ahead.
Sir, as you have mentioned that minority can establish their own educational institution for the protection of their community. So, any minority education institution established by their community, not aided by government, then they can take they can deny from taking admission of those students.
No, if they receive money from the state, they cannot deny.
If they don't,
then they can deny. They can deny, but still they will be governed by Article 14. It means that their denial must have a rational nexus with the cause of the denial.
Rational nexus with the cause of the denial. Yes. Sir, I live in Bihar. So, one more question, sir. There is a private person who opened the educational institution for the particular community called Brahma Samaj, called Brahmans and other communities.
See, legal advice I give for a fee, right? I do not give free legal advice.
No, sir. I am not. I am asking that is it a valid institution? He can deny on the basis of their caste, denying the admission.
No, caste cannot be denied. But again, I will have to look into more detail into facts before answering that.
Okay, sir. Thank you.
Yes, Mr. Navneet, go ahead.
Good afternoon, sir.
Good afternoon.
सर अभी आपने मेरा पेपर चेक किया है, आप पूछ रहे थे किसने लिखा है बालक या बालिका ने, जिसमें आपने 8 मार्क्स दिए, पुअर स्ट्रक्चरिंग वाला, वो मेरा ही पेपर है।
अच्छा, ओके।
बट आपने सर मुझे एक बात पूछनी थी, उस पेपर में मैंने पहली बार आंसर लिखा है, तो ऑल्दो मैं ठीक है मैं स्ट्रक्चर इंप्रूव कर सकता हूँ, बट क्या मुझे ज्यादा केस लॉस डालने की जरूरत है कंटेंट वाइज?
कंटेंट वाइज में क्या है ना कि अच्छे लाइंस केस से चुन के बिना मेंशन किए भी आप डाल सकते हैं, थोड़ा सा फिलोसफिकल एस्पेक्ट या थोड़ा सा लीगल लैंग्वेज और अच्छा प्रयोग कर सकते थे आप। कोई बात नहीं, आपने पहली बार लिखा है ना, आप धीरे धीरे इंप्रूव करेंगे। अगर ये कंटिन्यूअस आप अटेंड करते हैं तो यू विल डेफिनेटली इंप्रूव अ लॉट।
ओके सर, थैंक यू सर, थैंक यू।
Yes. 1 minute, sorry. Navneet have asked the question. I am going to, yes, Mr. Babua, yes, please go ahead.
So just kindly consult the question number. The question with heading is cam scanner, sir. So just kindly read it, sir, please.
Which cam scanner?
The folder you have opened is one document with the name is cam scanner. It's my question, sir, I guess.
Okay, I will evaluate. See, I am evaluating one by one. Let me answer I will reply your email also, not to worry. Okay, I will reply it. Okay.
Okay, sir.
Okay. Yes, I think next I will go to Mr. Ankul. Yes, Mr. Ankul, go ahead. If you have any question, do ask me.
Sir, there is a confusion regarding whether judiciary will come under the definition of state.
No, there is no confusion. There is no confusion. It is totally settled law. Judiciary in its judicial function is not covered under state, but judiciary in its executive function comes under state. However, a very interesting case happened recently, if you remember, that when this Mr. Prashant Bhushan filed a case that while determining, see, when a constitutional bench in the Supreme Court is established, it is established by the order of the Chief Justice of India, right? Now, the Chief Justice of India established a constitutional bench to hear a petition which was filed against the decision of the High Court, decision of the chairman of Rajya Sabha, not to move this impeachment motion against the judge, right? Now the Supreme Court, when this particular bench was established, then the Prashant Bhushan, in fact Kapil Sibal, the very first question he asked before the bench, that on whose order this constitutional bench have been established, okay, and I am entitled to know that order and challenge that particular order, right? But that did not happen. Okay, so it seems to suggest that the Supreme Court thinks that, okay, on judicial side I am not a state, on the executive side also I am not a state. Okay, so there is some confusion in that respect as well. Okay, Uncle?
Okay, so thank you. Yes, sir, thank you.
Okay, I'm unmuting other people as well, not to worry. Mr. John Wick, oh, yes, Mr. John Wick, I hope you will not kill everyone.
Hello, sir.
Yes, Mr. John Wick, please go ahead.
Sir, my question to you is that if we go by the Article of 12, then there is a term called other authorities.
Yeah, that is what the court have expanded in multiple cases, that what is the meaning of other authority.
So, sir, my question is that whether a private entity who is able to work or perform the public function, can they come under the ambit of Article 12 or not? That was my question.
No, right now they cannot. They cannot.
Okay, sir. Thank you, sir.
Okay, one by one. Mr. Soni. Yes, Mr. Soni, go ahead. Soni Sharma. Hello.
Good afternoon, sir.
Good afternoon, Soni. Yes, please go ahead.
Sir, I just got disconnected, sir. I just want to ask whether my copy has been checked or not, sir.
You have sent your copy? I will see. I have got around 18 to 20 copies, so I have shown just 2 and 3. Rest I will I will not check actually, but I will actually reply in the email that what are the things that you need to improve. Okay, Soni?
And sir, would you please re-show how the question has been framed in the copy you are checking? I just got disconnected, so I just
re-show will be not possible, but I am trying to record it, so I will send it to you. Okay, not to worry.
Thank you, sir.
But today I don't think everything failed today, right? I have to do it on iPad itself. So let me see if I can help you. Okay, Mr. SK, go ahead. Ask your question.
Good afternoon, sir.
Good afternoon. Please.
So am I audible?
Yes, you are.
So my query is in the context of Justice Siravai's views on Article 2 and 3 that in practice these articles are federal in nature due to states' demand by extra constitutional education to outer their boundaries.
Yes.
In this context, sir, you remarked that the removal of Article 370 and bifurcation of the state of J&K into the Union territories is an exception to Justice Siravai's approach, because in this approach the state's opinion was not taken. But in the consideration of the long-standing demand of people of Leh and Ladakh and to get Union territory status and separation from J&K, which has been pending since 75 years, and there was lack of development and a lot of
Understand? See, understood.
So, sir, just like Telangana, it was getting a lot of.
See, it is again not a legal question. It is simply a political. Okay, understood your point. It is simply a political question. Now, if you believe that the state of Ladakh, I mean the people of Ladakh, and this was demanding, then you can say that Justice, H.M. Sarawai approach is correct. If you don't believe it, it is not correct, right? So that is purely a political question. Okay, Mr. SK?
Okay, sir. Sir, just one query also, sir. Can we, sir, say that the creation of the states will create more federal units, so it will
yes,
lead to
no doubt. If the state demands that I should be divided and it is being divided, then it means it is more federal unit is being created. That is very correct.
Thank you so much, sir.
Okay. Yes, one by one I am SK is done. Now let me come to this Prerna Sarthi. Yes, Prerna Sarthi, please go ahead.
Hello, sir.
Hello.
Sir, I actually had a doubt on the Article 14-16 relation.
Okay.
I couldn't understand that part very. If you could just summarize it in 2 lines, it would be really helpful.
See, initially the court said that Article 15 and 16 is an exception to Article 14. Meaning that if some law has to satisfy the requirement of 16 and 15, then it also must satisfy the requirement of 14. Matlab ki first time it will be checked that whether it satisfies 14 or not. Once it do not satisfy, then the exception will be applied. If it satisfies, then it is valid. Now the court is saying that no, if a law satisfies Article 15 requirement, then automatically it will be assumed that it is satisfying Article 14 as well. Meaning, Article 15 and 16 is giving the effect to what Article 14 was actually telling.
So, earlier you needed to
I cannot hear you, Prerna.
14 also, right now you don't need to satisfy that.
Yeah, right now you don't need. Once 15 is satisfied, then done. Okay.
Okay, that's all. Thank
Yes.
you so much.
Yes. Devika, yes, please go ahead.
Yes, good afternoon.
Yes, good afternoon.
While attending the answers today.
Please speak little louder. I cannot hear you, Devika.
Okay, so can you hear me now? So am I audible?
Yes, you are.
Yes, sir. So while discussing the answers today, there was this point of the positive aspects. So there you said that this should be written para-wise and not point-wise. So if we have to write positive or negative aspects, can we not write it point-wise and why it has to be para-wise?
I actually told that do not write everything. In that copy, everything was point-wise. I told that you can write point-wise, but we write first paragraph, then you write point-wise.
Okay, right.
Okay, that was the problem.
Okay, sir. Thank you.
Yes, Mr. Susa Shahul, sorry. Mrs. I think suppose. Yes, please go ahead.
Good afternoon, sir.
Yes,
I'm Shuha Shahul.
Shuha Shahul, yes, please.
Yes, sir. So, I have a question.
Yes.
Sir, like when there is some philosophical question like the one you gave yesterday,
Yes.
how are we supposed to conclude the answer? Like, should we write what is there right now, or give our opinion and conclude it?
No, the best approach would be to conclude it with the recent Supreme Court decisions. That will be much better approach.
Okay, sir.
Okay, now I think rest. Yes, please go ahead.
Sir, good afternoon, sir. I
good
had a
afternoon.
slight confusion regarding the relationship between 14, 19 and 21. If you could explain it slightly briefly, sir.
Okay, see, what actually I told you that Article 21 provides due process, right? So if anyone executive is violating the right of life and liberty, then that particular executive order must satisfy the procedural equality in Article 14. First point. Second point, in the case of reasonable restriction imposed on the freedom of speech and expression, or any, for that matter, any of the freedom given in Article 19, again that particular thing must satisfy the requirement of Article 14, and also it should not infringe upon the right under Article 21. Okay, so that is the relationship.
Right. Thank you.
Okay. Yes, Mr. Nisant Misra, go ahead. Nisant.
Good afternoon, sir.
Yes, good afternoon.
Can you recommend some source to prepare for today's answer? Because not all these points are available in one place.
Understood. See, the best source is actually a book by Mr. What is the name of that book? The very famous. He was a historian but wrote a multiple book on India. Corner State of the Nation. That book actually you can study. Constitution of India, corner state of the nation.
Okay, sir.
That is, the PDF is online available freely. You can download it. Okay.
Okay, sir.
Yes. Now I am not looking at this. Whatever the people are, messaging me. Okay. So please raise your hand and I will unmute you here. Yes, Akhil, go ahead.
Sir.
Yes. Good afternoon.
Sir, I have a doubt regarding Article 29 and 30.
Yes.
So while interpreting the minority, hello, am I audible, sir?
Yes, you are audible. Please.
Yes, sir. So my question is, under Article 29 and 30, while defining minority, can we define it under state-wise or it has to be national perspective?
No, it has to be state-wise. It has to be state-wise.
Means like linguistic, Hindi is a linguistic minority in South states.
Yes, southern states. Yes, similarly the Tamil people will be a minority everywhere else except Tamil Nadu.
And yes, sir.
Yes.
And will it apply to the religious minority also?
Yes, the same thing will apply to religious minority as well. But there is a interesting case that came in before the Supreme Court, I think 2 years back, that in the Christian states.
2 years back it came.
Yes, in the Christian states of the Northeast India, the Hindus are still not minority there. So there was a petition of mandamus, direct the president to give them a minority. But that case, I think the hearing did not happen. So as and when the hearing happens, I will attend and I will then try to see what is the argument that is being made.
Yes, I had the similar doubt. I was not getting the citation.
Understood. So that hearing hasn't been finished right now.
Okay. And can you please share the question again? I could not note it down.
Okay, I will share on the group itself. Not to worry. Okay, Akhil?
Okay. Thank you.
Yes, Mr. Sudarshan, go ahead.
Sir, I have this doubt, as per Article 13, state is responsible if it violates the fundamental right of people. But as per principle of sovereign function in tort, it is not responsible for the act of state. So, is there contradiction?
No, not at all. See, when we are talking about sword, I think you are referring to Harilal Jain case, right? So actually in that case what happened, that if some personal wrong, a tortious wrong have been committed, then the state is not liable. Now but that particular judgment that the state is not liable for performing the sovereign function, non-sovereign function by its servant, that judgment is basically a stupid judgment. It have been watered down later on, right? So Supreme Court have overturned it, right? So right now whether you are performing sovereign or non-sovereign function, still you will be punished. Like for an example, अभी ये जो PNB वाला case हुआ था, so in the case of PNB, the employee at the PNB branch, that bank manager was doing some wrong, right? Now the PNB took the plea that I am a state and that particular employee was performing a non-sovereign function from my side, so I am not responsible for the act of that particular employee. Now that particular reasoning, if accepted, the whole financial system that is based on trust will collapse, right? So that is why the court have not taken that particular view. Okay, it means it is consistent with the fundamental right.
Okay, thank you, sir.
Yes, Mr. Akshay, go ahead.
Sir, hello. Sir, am I audible?
Yes, you are audible. Go ahead.
Sir, you explained Article 13 today, and you just took only one aspect of it. So that
I have not discussed Article 13 at all. I will discuss it when I will talk about constitutional amendment.
Okay, so sir, in that judicial review concept will also be there.
Yes. Obviously, Article 13 is the base of judicial review. We will cover that.
Yes, okay. I thought so that we don't have to study that part at all.
No, you have to. Okay. Sorry. Yes, this is the last question, Ankit. I have to class from 12 to 2:30. Yes, Ankit, go ahead, please.
Yes, sir. If you could again recommend the book, tell the name of the book which you have recommended.
Which book?
For today.
Okay, right now, this Constitution of India, corner state of the nation. Granville Austin.
Thank you.
No, SK, you have asked your question. I am not going to unmute you again. Okay, ask your question one by one. Okay, if I will give everyone opportunity, that will lead to a disastrous thing. Okay. Yes, email ID. Someone is asking. The email is defactolaw.in. The website address @gmail.com. Right? You can send there. Yes, I will update the PDF lecture in the today group itself, because on this iPad I don't know how to do it actually. Okay everyone, yes, so let us end the meeting. Let us meet tomorrow. Okay, corrected answer, yes, you can email on defactolaw.in@gmail.com. I will reply that. Okay, so let us end the meeting for today. Thank you everyone. Sorry.